Perfect. Priyanka ma'am.
हाँ जी.
Priyanka ma'am, you had to log in a little bit early because now we don't have much time. Ma'am, so I'll just tell you your cues at 6:21. Sorry,
Yeah.
post Hari sir's thank you to Jayaprakash sir in the end. He will call for you. All right.
हाँ.
And I hope, ma'am,
Yeah.
you've logged in from 2 devices.
Yes, I'm doing that right now in the second device itself.
Yes, ma'am.
Yeah.
But you need to follow the rules which I said yesterday on the group. The second device that you're logging in will be your queue devicing. So that'll only be just for your reference. The video
Okay.
of that device should be off. The device should be on mute, and the
Yeah.
device volume should be 0.
Okay. Got that.
Yeah.
हाँ. The other device you mean, right? The audience device.
Yes, the audience device should be on muted, like
Yeah.
completely
Okay.
shut.
Got it.
Yeah.
Got it.
Once you see
Yeah.
yourself in the screen, ma'am, that will be your cue to speak.
Okay. Okay. Okay.
Hello, hi, Jasim sir. Good afternoon.
Hello.
How are you, sir?
Very good, thank you.
Perfect, sir. So you're talking to a gentleman named Numan from India. Lots of love, sir, for you and prayers.
Thank you very much.
So, all right, sir. So now we have logged in. You have logged in from your performance device, sir. So basically, when Hari Kishan sir will introduce your Anurag sir will come and introduce you. Once that introduction is done, sir, there'll be an intro video played on your name. It will
Sorry,
be a
I'm just trying to change my background as you wanted. So I'm looking for that. How do we do that? The background? Can you help me with that?
Check, check.
Yes, can you hear me?
Yes, sir, we can hear you loud and clear.
Yeah, I'm trying to change my background. So,
sir, if it's okay if I mean, is it necessary? Jayaprakash, Hari sir.
What I will do, I will send it to Mr. Jasim now.
I have it. I have the JFIF file, but actually the can you send it to me in a JPEG format, please? Because the one I have is in a format which cannot be.
File.
Yeah. Can you send it to me, please? Am I audible properly?
Yes, sir.
Yes, sir.
Okay, excellent.
Yes, sir, you are audible properly. Your video is clear, and your internet speed is, mashallah, very good. So just reiterating the sequence of events. So your cue to speak will be when a video ends. So, sir, are you in touch with any of the ICI members directly, like Hari Kishan sir or Sundar Nurani sir on phone?
I am in touch with him.
All right, so Sundar sir, you will have to inform Jasim sir over WhatsApp that his time is to speak.
Okay.
Okay, so once the introduction video plays, okay, 30 seconds after that, you'll have to put a message to Jasim sir saying that he has to speak.
Okay, that's fine, no problem.
Yeah.
And can you please take care of Mr. Jasim's background?
Yeah, if someone can send me the background in JPEG format, because the email I got was in a different format.
Mr. Jasim, I have sent you by WhatsApp.
Yes, got it, Sundar.
Yeah, So you can send it to you by email, and you can put it in the backdrop.
Yes, yes, I got it.
Yeah, thank you. Noman, you want to see the lighting for Mr. Jasim?
So, Jasim sir, if you can, so there's light coming from behind.
Yes.
So
You want
once
me
you
to
put
change it?
your virtual filter on, sir, that device won't catch up with the lighting. So if you can
Yeah,
just
now it is
sit
okay.
against the wall, yes, this background is perfect. All right. Now, if you
Yeah.
can add the image that Sundar Narani sir has sent it to you.
Noman, I need to inform Mr. Jasim 30 seconds after the video.
Yes, 30 seconds after the
Okay.
video.
Yeah, okay.
Jasim
Okay,
sir,
so
Jasim sir, once you receive that message, just wait for 30 seconds more and then you start speaking.
okay, I think my background is flipped. So
No, sir. It's perfect. We can see the
It's perfect,
background
yeah.
very well.
okay, I see it flipped. Okay.
Yeah, because your Zoom might be mirrored, which is why you might be seeing it flip.
Okay,
It's
okay,
sir.
okay,
We have
excellent.
it figured out at our end. All right,
Very
sir.
good.
So it's 2:55. We have 5 minutes for the show to start. All the best, everybody.
Norman,
Yes.
can you log me on audience?
You're already there, sir.
No, I'm not there. I'm on the performance on the
Yes,
laptop.
yes, sir.
and
We'll
I'm
be
trying-
logging even since you've logged in as AGP technical team. We cannot see who's who.
Don't worry. Once we admit all, you will be able to see yourself.
Okay.
All right. So we are opening up the waiting room and requesting you to please be on mute. We'll be sending you an unmute prompt. Jasim sir, it's fine. You don't have to go on mute. We'll take care of your settings. All right. Sundar sir, I need your go ahead to start the event.
Yeah, thank you.
Sundar sir,
Please
I'm
go ahead.
posting on the groups as well for joining the session starting in 5
Yeah.
minutes.
Thank you.
Yeah, please.
All right. So we are going in with the banner and the house music.
What? Chief guest, Mr. Jasim Al-Siddiqui. Speakers of the day, Mr. Abhimanyu Jalan and Mr. Matthew Sanan. Our Galaxy of Past Chairman, Chairman C.A. Sundar Nurani, Vice Chairman C. Anurag Chaturvedi, respected members of the chapter, and my colleagues in the managing committee. A very good afternoon to all of you. I welcome each one of you to our virtual conference, UAE laws relating to financial management of businesses, commercial companies laws, bankruptcy law, economic substance regulation, ultimate beneficial ownership, and anti-money laundering. First of all, our chief guest, Mr. Jasim Al-Siddiqui, CEO of SUA Capital, for taking out the time out of his busy schedule to address all of us today. Now I request all of you to rise to the national anthem of the UAE and India, followed by the ICI motto. I request our technical team to start the national anthems and our ICI motto.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
य एष सुप्तेषु जागृति य एष सुप्तेषु जागृति कामं 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 कामपुरुषो पुरुषो निर्विमाणः निर्विमाणः तदेव शुक्रं तदेव शुक्रब्रह्मा तद्ब्रह्मा तदेवामृतमुच्यते तस्मिन् लोकः शतः सर्वतदुनात्यपि कश्चन एतद्वैता 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 एतद्वैता
Thank you. Please be seated now. There is a wise saying by famous writer Charles Dickens, if there were no bad people, there would be no good lawyers. Ladies and gentlemen, we have got two prominent lawyers amongst us today from Clyde & Co, who is our platinum sponsors as well. I thank Mr. Abhimanyu Jalan and Mr. Matthew Sanan to accept our request for addressing our members today on UAE laws. Now I would like to thank our sponsors who have always supported us in all our endeavors. Our principal sponsors, Danube Group, Kelly, Lulu, Shura. Our platinum sponsors, Clyde & Co., AGMC, Century Financial, IFCO, TIF, Dun & Bradstreet. I also thank our media partner, Khalij Times, institutional partner, Delhi Private School, and banking partner, Bank of Baroda. I also thank each one of you for your participation in this virtual conference and wish you all a great learning. Now I request CA Sundar Nurani to deliver his chairman address. Over to you, sir.
Thank you, CA Harikishan. Chief guest are today Mr. Jasim Al Siddiqui, CEO of Shua Capital. Eminent guest speakers, Mr. Matthew, Mr. Abhimanyu Jalan, partners, Clayton Company LLP. Our Galaxy of Past Chairman, ICA Dubai Chapter Vice Chairman, CA Anurag Chaturvedi. Members of the chapter, my colleagues in the managing committee, invited guests, our sponsors and their representatives, ladies and gentlemen. Ramadan Kareem and a very good afternoon to all of you. Today's topic is very critical to all finance professionals as the speakers are going to enlighten us about the recent amendments to Commercial Companies Law, Bankruptcy Law, ESR, UBU, and the much talked of topic, anti-money laundering. After listening to the speakers, members will have enough and more time to clarify all the questions with our learned speakers. We have around 800 registrations for today's event. That shows the importance of the topic and the commitment of the members on continuous learning and reskilling. We have successfully completed 2 CPE events and 2 focus group events under the new managing committee in the last 2 weeks and have planned a variety of CPE events considering the reskilling of the members in mind. Some of our upcoming CPE events in April and May include performing business valuations and business feasibility studies in turbulent times, life lesson to pass on to younger generation, for which Sri Narayana Murthy, founder of Infosys, and His Highness Sheikh Salam and Dr. Azad Mupan will be addressing the members, risk management, corporate governance and internal audit. And we have Women Tech coming up in May, navigating through turbulent times, accounting and auditing considerations for going concern, material uncertainty, impairment, and debt restructuring. These are some of the events planned in April and May. I again welcome all members to suggest a topic and connect us with the speakers, which the managing committee will explore. And if it is in the wider interest of the members, we will plan the events accordingly. The managing committee is working round the clock and doing their best to ensure that members get the best learning and best virtual experience. The Indian Income Tax CPE event by CA Vir Jain, past president of ICAI, was attended by more than 700 members, and all the doubts of members were clarified by the speaker. Today we had around 30 members attending the Power BI workshop, which is very important for finance professionals. This workshop will run for 3 days, and I thank CA Jaiprakash Agarwal, our ExCom member, for organizing this workshop, which is very, very critical for the reskilling of the members. Facts focus groups first event of yesterday was attended by around 150 focus group members who discussed about, is there a change in the VAT treatment by our member CA Mayank? Thank you, Manoj Agarwal, for arranging this session. We have various focus groups under the chapter to cover different industry and topics such as healthcare, education, banking, IFRS and audit, retail and real estate. And if any of the members want to join the group, they can get in touch with Secretary CA Harikishan. Last week, we had an event for the CA students, which was attended by around 100 students plus, and our member CA Sashikala shared the exam tips. And thanks to our ESCOM member CA Amit Ketan for organizing this event, with Jay Prakash for supporting the logistics. Considering the well-being of the members, we have organized badminton coordinated by Manu Nair and Harikishan, and cricket tournaments coordinated by Treasurer CA Manoj Agarwal and Rishi Chawla and Jay Prakash Agarwal, our executive members, for the members in April and in the month of May. These events will be conducted keeping in mind the COVID-19 protocols set by the authority, and only those members who are participating will be allowed to attend these events. Safety and well-being of the members is the topmost priority for the chapter, and the option of doing the hybrid CP events is under contemplation within the managing committee. We are looking into the options for doing the physical CP events too. And as and when we get the clear visibility, we will consider conducting events physically, which can be attended by limited members, considering the capacity protocols, and the rest can still attend virtually. For these, we need to have the consent from all, including the government authorities, as well as the speakers. Today's virtual event under the Zoom platform is managed by AGP World, who supported us during the last annual conference. We thank their team for the support and request the members to share their experience about this virtual platform.
Yeah, I did it.
Yesterday, we had the vaccination drive organized by Manoj Agarwal, treasurer, and many members got vaccinated. And thanks to CA Dinesh Kodari Saab for providing us with the venue, DPS Sharjah, along with the support staff for vaccination. And sincere thanks to our volunteer, Sri Pritesh Goenka, for volunteering during the vaccination drive. As part of our corporate social responsibilities, we have tied up with a social organization for the distribution of iftar meal packets to labor camps during the holy month of Ramadan. Treasurer, along with his team, are focusing on reminding the members for renewing their membership at the chapter. And I take this opportunity to request all the members who have not yet renewed their membership to regularize Jasim Al-Siddiqui for gracing this occasion with his esteemed presence despite his busy schedule. And I also thank our esteemed speakers, Mr. Matthew, Mr. Abhimanyu, for taking time out for sharing their valuable experience and knowledge, which is very essential for the members in practice as well as in industry. Thank you all. Stay safe, stay blessed. Salam alaikum. Over to you, Harikishan.
Thank you, Chairman Saab, Sundar Norani Saab. Thank you very much for your kind words and letting us know about the forthcoming events. Now our chief guest, Mr. Jasim Al-Siddiqui, CEO of Shua Capital, will be addressing all of us. I request our chairman, CA Sundar Norani, again to welcome our chief guest, Mr. Jasim Al-Siddiqui. Sundar Saab.
Thank you, Mr. Jasim, for accepting our invitation to address the members. Can I ask technical team to play the video, introduction video?
Ladies and gentlemen, today we have Jasim Al-Siddiqui, Group CEO of Shua Capital PSC. Jasim Al-Siddiqui is the Group Chief Executive Officer of Shua Capital, the leading asset management and investment banking platform with USD 14 billion in assets under management. Jasim is known for his dynamic and innovative approach, having pioneered many investment strategies in the region. He is currently the chairman of GFH Financial Group, Islamic Arab Insurance, Ishraq Investment, Khaliji Commercial Bank, and The Entertainer. He also serves on the boards of First Abu Dhabi Bank, ADNOC Distribution, and Dana Gas. Jasim holds a BSc in Electrical Engineering from the University of Wisconsin-Madison and an MSc in Electrical Engineering from Cornell University. He has also served as a noted lecturer at the Abu Dhabi-based The Petroleum Institute. Ladies and gentlemen, please welcome Mr. Jasim Al-Siddiqui.
Members of the Institute of Chartered Accountants of India, Dubai chapter, and friends. I am delighted to be here with you today, and I would like to thank the ICAI for organizing this virtual event and for kindly inviting me to speak. When the pandemic threw so many businesses across the world into panic last year, technology was widely credited as being the hero and the solution of our survival. And of course, from work to learning, from socializing to shopping, from eating to entertainment, technology has played a crucial role in helping us continue to live the best as we can, as if it has been the pre-pandemic. But there's no doubt that technology has helped businesses cope through the changes and challenges of COVID-19. But there is another whole group of people who haven't received enough credit, and that's you. Because it wasn't big technology that found ways to keep companies in business when money was tight, or paid the bills to keep the lights on and invest in the technology needed to keep them running, or deal with the extra costs of COVID-19 and the cost of disruption and so on. It was accounting and finance that made these things possible. Your work is not just about numbers, spreadsheets, and principles of accounting, but also about forward thinking and foresight. It is the ability that has always helped us as a business and the UAE as a nation to focus on the future and differentiate ourselves. Exceptional vision and planning by our country's great leaders have enabled the UAE to transform itself from a desert and fishing village into a global economic powerhouse and commercial hub for investment, tourism, and trade, not only in the Middle East, but also today on a global level. In just 50 years, the UAE's GDP has grown 230 folds, from 6.5 billion dirhams to 1.5 trillion dirhams in 2020. Sometimes people say the UAE is successful because of its oil reserves. But many countries in the world are rich with oil and gas resources. How many have success stories like ours? The UAE is the shipping and trading hub of the Middle East. In fact, Jebel Ali has been one of the 10 busiest ports in the world for many years, and Khalifa Port is in the top 100 in the world. Our homegrown airline brands like Emirates and Etihad have earned a global reputation. Dubai International Airport is the world's busiest international travel airport. Dubai International Financial Center and Abu Dhabi Global Market filled the trade gap between London and Hong Kong, making the UAE a financial center for the Middle East. So the difference is that we have used our natural resources well to plan carefully in the past, for the present, and now for the future. Today, oil revenues account for less than 30% of the UAE's GDP. And as His Highness Sheikh Mohammed bin Zayed once said, 50 years from now, when we have loaded the last barrel of oil, will we be sad? If our investment is right today, we will definitely celebrate that moment. We have a diversified innovation and knowledge-based economy and thriving sectors such as tourism, retail, real estate, manufacturing, healthcare, technology, and even space, as we have seen last year with the Mars probe. What is more, we continue to improve our world-class infrastructure and business environment. The World Bank's Ease of Doing Business Report 2020 ranks the UAE 16th in the world, and we have been leading the Arab world for 7 years. Taking advantage of our geographic location, thriving business ecosystem, and quality of life, all Fortune 500 companies have a presence here, and we are a prime location for both large multinationals looking to establish the regional headquarters, but also as well as supportive environment for SMEs and innovative startups looking to launch, test, and grow their businesses. In fact, Despite the extraordinary market challenges last year, which saw 42% decline in FDI, hundreds of investors chose to invest in Dubai to grow their future businesses. The FDI Global Cities of the Future 2021 report published by FDI Intelligence ranked Dubai third among the top FDI locations in the world. Dubai also ranks second globally in major cities for FDI. These achievements are a testament to the resilience and stability of our economy and an important indicator of future investor confidence. Looking ahead, the UAE offers diverse business and investment opportunities for investors in several strategic and forward-looking sectors, like financial services, logistics, hospitality, and retail, as well as technology. The way we excelled in the COVID-19 response and started the recovery phase in record time demonstrates our commitment to providing the best investment environment in the world and turning global challenges into new growth opportunities. The UAE is very well known for turning challenges into opportunities, and we have proved to do that over the past 50 years. To this end, our agile government has proactively introduced new laws to attract foreign investment and promote entrepreneurship. The most notable development was the 100% participation of foreigners in companies licensed and registered in the UAE. To further boost investor confidence, we have also seen the introduction of economic substance regulation, ultimate beneficial ownership, anti-money laundering, and bankruptcy laws that make the UAE a fully compliant international player in the global tax economy and community. Over the years, Indians have continued to invest in the UAE, including in the corporate and real estate sectors, and the investment from the UAE into India has also steadily increased. Of course, the relationship between our two countries goes back a long time. More than 3.3 million Indians live in the UAE, and we see the Indian diaspora as an important part of our country's success. Just to give you a perspective, and this is something that I have heard and learned from our previous generation. In 1964, from Abu Dhabi, to go from Abu Dhabi to Mumbai, our grandfathers used to take a trip from Abu Dhabi to Dubai, and then from Dubai to Sharjah RAF military base, take a flight to Karachi, and then from Karachi, take a flight to Mumbai. It would take almost 3 days to go from Abu Dhabi or Dubai all the way to Mumbai. Today, we have 20 flights per day from the UAE to Mumbai. And this is just an indication of how close and important this relationship has been forming over the past 50 years. India is a strategic partner for the UAE, and according to recent reports, policymakers are forecasting that our trade relationship has the potential to reach to a total of $100 billion per year. And I am sure that the Expo 2020 will further expand the growth of our mutual trade as we work together for the grand success of this important international event. Thank you again for inviting me to speak today and for the role you continue to play in helping businesses and the economy understand financial positions, solve problems, and plan for the future. Thank you very much.
Thank you very much, Jasim Saab, for appreciating the efforts of chartered accountants to navigate the businesses through these tough times And thank you very much, sir, once again for sharing your valuable thoughts with our members. Now I request our chairman, CA Sundar Nurani, to present certificate of appreciation for Mr. Jasim Al-Siddiqui.
Thank you, Mr. Jasim. It was so kind of you to accept the invitation and address the members. The message given by you is well noted. We will support the UAE economy, and we do respect the strategic relationship the leaders of both India and UAE have paved, and we are happy to work with the community. And we thank you very much for your time. Can you please display our appreciation certificate? A small token of appreciation from all the chartered accountants, Mr. Jasim. Thank you for your time. Again, Ramadan Mubarak and Assalamu Alaikum.
Thank you very much. Thank you.
Thank you. Now I request our ExCom member, CA Rishi Chawla, to introduce our first speaker, Mr. Abhimanyu Jalan, who is going to address us on commercial companies law. Rishi, over to you.
Thank you, Harikishan, for giving me this opportunity to introduce Mr. Abhimanyu. Good afternoon, ladies and gentlemen, and wishing you a happy Ramadan. It's a great pleasure for me to introduce our speaker today, Mr. Abhimanyu Jalan, who's going to talk to us about the commercial companies law. This is a subject in which we should all be deeply interested because it lays foundation of how companies are regulated in UAE. Abhi is a partner with Clyde & Co LLP. He has been representing and advising clients in connection with the investments and business in the Middle East, Africa, and the Indian subcontinent for over 2 decades. A multi-specialist partner in Clyde & Co's Middle East corporate practice, Abhi has successfully led numerous high-profile and complex merger and acquisitions, restructurings, joint ventures, and public-private partnerships, including in business sectors relating to power, healthcare, retail, and telecommunications. Experienced on all aspects of acquisition, structuring, deal negotiation, and documentation, Abhi advises in relation to the full range of transnational acquisitions and other major corporate investment transactions. His clients include private equity entities, financial intermediaries, transnational corporations, both listed and unlisted, family offices, and governments. Ladies and gentlemen, please join me in welcoming Mr. Abhimanyu Jalan. Thank you.
Thank you, Rishi, and good afternoon, ladies and gentlemen. Please allow me to start by saying Ramadan Kareem to each one of you, and I pray that we all safely sail through the prevailing pandemic. My name is Abhimanyu Jalan, and I am a partner with Clyde & Co, as Mr. Rishi had mentioned, which is one of the largest full-service law firms in the region. I am qualified to practice law in Ontario, Canada, England and Wales, India, and have been advising corporations for more than 25 years. I have been based in the UAE since 2004, and it is my pleasure to share the financial aspects of commercial companies law and the bankruptcy law with you today. I will be today focusing on some new laws or amendments to key laws which affect the financial management of businesses operating in the UAE. In terms of what we will be covering today is we will be covering the UAE commercial companies law, the bankruptcy law, overview and recent changes, and my partner Matthew Shanahan will cover economic substance regulations, UBOs, and anti-money laundering regulations. The Decree Law number 26 of 2020 contains significant amendments to the UAE commercial companies law. This law comes 5 years on from the introduction of the law in 2015, which was to modernize the UAE company law regime. The decree law makes changes to about 51 provisions of the commercial companies law and introduces 3 additional provisions, almost 40 of which are aimed at joint stock companies. the press headlines really focused on the abolition of the foreign ownership restrictions, which was enshrined in Article 10 of the Commercial Companies Law and required at least 51% of the capital owned by a UAE national or a company wholly owned by UAE national. The decree law rewrites Article 10, and effectively the requirement in relation to UAE national shareholding has been reversed. Before, it was not permitted to have majority or wholly foreign-owned entities unless an express special exemption applied. These special exemptions were contained in the Foreign Direct Investment Law, which was the Federal Law number 19 of 2018, which allowed up to 100% foreign ownership in certain sectors against higher capital requirements. The FDI law was repealed by the decree law with effect from 2nd of January 2021. Now, instead, the decree law permits wholly foreign-owned companies unless a special exemption applies to restrict them. The cabinet is yet to issue a list of so-called strategic impact sectors, which will continue to be subject to restrictions on foreign ownership. The new foreign ownership rules came into effect from the end of March, but we are still awaiting for the cabinet to issue the list of strategic sectors. The issuance of this list will be really critical to understanding what the practical impact of these changes will be. The other key changes which have been brought by the decree law are creation of subsidiary regulations. We know one clear theme is that we expect more legislation to come here. This ranges from corporate governance regulations for all companies to detailed listed companies regulations to be issued by the SCA, including covering topics such as related party transactions, convening PGSC meetings, recording meetings, and electronic share certificates. There is a reference to the fact that to be issued governance regulations will apply to all companies, not just joint stock companies. This could bring welcome standards into the conduct and governance of LLCs in the UAE. There have been changes to the meetings and there have been amendment to the process of convening and holding general meetings for LLCs and the PGSCs. It is important to note that when it comes to financial management, because to be valid, the regulations need to be complied with and meetings properly convened. There are new provisions which address companies in financial difficulties, and the bulk of the PGSC regulations which affect the governance of PGSCs. When it comes to the auditor rotation rules, I will come to that momentarily in a further slide down. As mentioned, companies carrying on activities with a strategic impact will continue to be subject to restrictions on foreign ownership, for which we are still waiting publication of the cabinet decision outlining the scope of these strategic impact activities and particular controls for the licensing of them. It will be interesting to see whether this list of strategic impact activities will correspond to the negative list under the now repealed FDI law, where 100% UAE ownership was mandated across 13 sectors, including banking, insurance, and commercial agencies, or whether it will be broader. Technology, sustainability, the environment, infrastructure, and transportation, healthcare, and education play a central role in the UAE government strategy. With this new status quo, it is also possible that the government will look into the substance of the UAE national involvement in companies operating in these sectors, in which both UAE national and foreign investors hold shares. Subject to any mandates of the cabinet in relation to the strategic impact activities, the power to issue decisions on the contribution of the UAE nationals to the capital of the companies has been devolved to the government of individual emirates. This was also the position under the now repealed FDI law. It does raise the question as to whether we will see policy differences between emirates as to percentage of permitted ownership and level of capital contribution required for higher level of foreign ownership. Also, in the longer term, it is possible that the level of Emirati ownership in local companies may have an impact on the applicability and or rate of corporate taxation if this is introduced in future. Article 151 of the Commercial Company Laws has also been amended to remove the previous requirement that the chairman and majority of the board of directors of a joint stock company be UAE nationals in favor of specific restrictions which would be subject of future regulation. Another significant development is the removal of the requirement for foreign companies to appoint a UAE national agent in respect of a branch office registered onshore in an emirate of UAE. The practical impact of this change is not yet clear, but it could present an opportunity for cost savings for foreign companies operating in the UAE through onshore branch offices. When it comes to the limited liability companies, the decree law has increased the notice period for the general meetings to be at least 21 days, up from 15 days. This reverts back to the pre-2015 CCL position. And in addition, the quorum for valid meeting has been reduced from the shareholders representing 75% of the capital to 50% unless a different quorum is specified in the memorandum of association. The number of reconvened meetings, in case the first general meeting is not quorate, has been reduced to 1 at which any shareholder present can constitute the quorum unless the memorandum provides otherwise. Modern means of sending notices and holding meetings under Article 93. LLCs may provide for modern technological means by which notices may be sent to shareholders by specific provisions in their respective memorandum of association. This may include email and instant messaging, for example. The commercial company law also allows meetings to be held by modern technological means, which enable remote attendance, such as video conferencing. There is an additional requirement on the company to file a copy of the invitation of the meeting with the competent authority, which is the DED. It remains to be seen whether the local economic departments will enforce this requirement on LLCs, as historically other company filings have not been accepted despite provisions to this effect in the commercial companies laws. With respect to dispute resolution, a new provision mandates that the memorandum of association of each LLC must contain methods of dispute resolution between the company and its managers, as well as between the shareholders. I am referring, gentlemen and ladies, to Article 73(2). Traditionally, the memorandum of association is viewed as an agreement for the incorporation of a company regulating the relationship between the shareholders of that business. However, this new article suggests that it is intended to be a contract which deals with the relationship between the company and its managers as well. If this is the case, the manager and the company may need to be parties to that agreement for it to bind them. Few memorandum of associations currently provide for this. This would potentially entail a new memorandum of association each time the manager is replaced, and the manager being required to sign each time amendments are being made to the memorandum of association by the shareholders. The nature of the manager's role as an employee may also be important to consider in this context, including the effect on labor law rights such as disciplinary processes and termination protections and the specific terms of the manager's service contract. It will take time to understand how these provisions will be interpreted and implemented in practice. Various subsidiary regulations are anticipated in the law regarding corporate governance, single shareholders memorandum of associations, and controls and conditions for LLC general meetings. All of these may have further impacts on the drafting of the memorandum of association and the management of LLCs generally going forward. As advisors to the client, we would recommend that you keep an eye on all these forward-looking changes, anticipations, and uncertainties to help them do their business as efficiently and smoothly as it is possible. Article 104 of the Commercial Company Law carries relevant joint stock companies provisions across to LLCs. This was a controversial provision when it came in force way back in 2015. There was a lot of concern at that time in relation to some of the PJSC provisions, which might carry over to LLCs. I am sure most of you will recall that. In particular, the provision prohibiting a company from providing any financial assistance in connection with the acquisition of its own shares caused concern in the acquisition finance sector. Clarity as to which of the provisions carried over and which did not was eventually provided by the Ministerial Resolution number 272 of 2016. Helpfully, that resolution confirmed that the financial assistance prohibition in the changes brought in by the degree law, the new Article 104.2 states that a cabinet resolution will be passed to provide clarity from now on. So effectively, Resolution 272 will no longer have force of law, at least in respect of provisions which contradict the degree law after 2nd of January 2021. At the moment, we believe we can rely on Resolution 272 for guidance where there is no express contradiction between what that resolution says and the provision of the Commercial Company Law itself as amended by Decree 26. It is unfortunate that this point was not properly addressed in Decree 26 itself and is a gray area at the moment. Based on the approach taken in Resolution 272, the following changes made to the PGSC provisions are likely to affect the LLCs. Extension of managers, directors, and liability to members of the company's executive management is the first one. There is a clear move to extend liability to certain key managers who may not be directors. These include the CEO, the general manager, and the executive manager. Given the closely held nature of many LLCs, this extension will only affect a relatively small proportion of the significant LLCs which have a professional management team, as well as a board such as large family-owned businesses. Practically, when it comes to how you deal with this, it may be prudent to keep an eye on the insurance coverage for the liability which any of these affected businesses may have. Article 162 provides for the disqualification of any director or executive manager against whom a final judgment has been received in relation to fraud, conflict of interest, or misuse of power, and that disqualification period extends for up to 3 years. The term of the auditors, the amendment allows the same auditor to remain in place for up to 6 years rather than 3, with a change in the lead audit partner after 3 years. The same auditor may be reappointed after a 2-year gap. Resolution 272 provides Article 243, which is dealing with auditor rotation, but confusingly does not deal with rotation specifically in the other provision it contains in relation to auditors of LLC. So from a legal perspective, the position is not totally clear. Although strictly speaking, the rotation requirement do appear to carry over to LLCs. We do appreciate and understand that in practice, this may not apply to LLCs. However, we need to watch the space in this. Currently, LLCs are not subject to the related party transaction provisions under the Commercial Companies Law. The new Article 104, subclause 2, however, refers to the new cabinet resolution containing provisions to be applied to the LLCs dealing with the related party transactions. Therefore, a specific regime seems to be anticipated for LLCs. Let's see when that regime is made more public. Other changes which have been done, the investment management has been removed from the list of business activities restricted to public joint stock companies, opening up the possibility for both LLCs and private joint stock companies to carry out these activities. Banking and insurance business will still only be carried out by public joint stock companies. Other noteworthy changes include a minority shareholder protection provision in Article 92, allowing shareholders holding 10% or more of the capital in the company to request a general meeting. Resolution 272 contains a similar right for shareholders for holding 20% or more of the capital and holders of 10% or more having a right to ask the DED to call for a general meeting if an emergency arises to pass an extraordinary resolution. As discussed, this represents an effective repeal of Resolution 272 with effect from 2nd of January 2021. There is also a new provision allowing for the LLC preemption rights on new issue of shares to be overridden by the court on application of any partner if new capital is needed to prevent dissolution of the company. The decree law envisages the issuance of a SCA decision on the corporate governance. It is a bit unclear whether the current SCA corporate governance guide for public JSCs, which was only issued last April, will be updated or repealed or replaced. Interestingly, the guide was very recently amended by the SCA in relation to the female board representation. From 14th of March 2021, it is now mandatory for the UAE PJSCs listed on either Abu Dhabi Securities Exchange or the Dubai Financial Market to have at least one female board member. So the 2020 guide seems set to remain in place for the foreseeable. As with LLCs, the notice period for calling a shareholders meeting has been re-increased from 15 days to 21 days. The new provision also provides for flexibility with regard to holding and attending meetings via modern technological means, subject to the controls issued by the SCA. As a COVID-19 response measure, the SCA issued a decision to the public JSCs that it regulates to permit the holding of virtual shareholder meetings via modern technological means. And the SCA issued a decision to the public JSCs, joint stock companies, that it regulates to permit the holding of virtual shareholder meetings and to vote via virtual methods. So this is not a new practical consideration for such entities. We have already spoken about the auditor rotation for PJSCs, which is 6 years versus earlier 3, although lead audit partner must change after 3 years. A number of provisions affecting the ease with which public joint stock companies can raise capital and issue debts are welcome additions to the amendment law. The CCL previously imposed liability on third-party advisors in respect of the accuracy of the company's prospectus. Under the decree law, this liability now rests only with the founding committee and our board of directors as applicable. Third-party advisors, nevertheless, retain their obligation to perform their work with due skill, care, and diligence. In addition, the maximum free float requirement of 70% may be increased with the permission of SCA, while the lockup period for founding shareholders has been reduced from 2 years to 6 months. It remains to be seen what will happen under Article 10 and the knock-on effects it will have for Article 151 and UAE national participation on boards, but a potential relaxation on the current board composition requirements in favor of foreign nationals would no doubt be welcomed by the international investors. Positive changes to the strategic investor regime, which allows the public joint stock companies to issue shares to investors on a preemptive basis under certain criteria, have also been included. In particular, the removal of certain criteria for strategic investors to provide 2 years financial reporting history and to operate in a similar business activity in the public JSC that it wishes to invest in is a welcome addition. The removal of this criteria opens up the strategic investor regime to a greater pool of investors and potentially investors as opposed to just corporates. The decree law provides that preemption rights will not apply in respect of convertible bonds and sukuks. The SCA had previously applied this approach in practice, but this addition to the commercial companies law provides helpful clarification. In addition, a right to a prorated dividend in the financial year on the conversion of a bond or sukuk to shares is permissible, subject to anything to the contrary in the prospectus or the issuance terms of the bond or sukuk. Again, this provides clarification that the bond issuer can set out terms for the payment of any dividend in the issuance terms and conditions. The decree law also removes the 1-year time limit that exists under the commercial companies law for the board to act on a special resolution of shareholders approving the issue of a bond or sukuk. This is a helpful provision as the time limit has created a requirement to have an annual shareholder meeting addressing the point for issuers with wholesale funding programs regularly accessing the capital markets. This was arguably overly administrative. The UAE Takeover Code has been given more teeth under the commercial companies laws, including specific references to a squeeze out of the minority and new powers for the SCA to deal with breaches, including warnings and suspensions. Although these are already within the code, issued under the SCA Resolution 18RM of 2017 regarding the rules of mergers and acquisition for public shareholding companies, it is an important step to enshrine into the primary legislation. The existing related party, just go back one more slide. The existing related party transaction regime applicable to the joint stock company has been expanded. Additional disclosure requirements have been included. These disclosure requirements include prior to entering into a related party transaction, the related party must disclose to the board of directors the nature and terms of the transaction and all essential information concerning its shareholding in the relevant companies/related parties, including the extent of its interest or benefit from the relevant transaction. A notification requirement when entering into a related party transaction for the chairman of the board of directors of the relevant joint stock company to notify the relevant authority, that is the SCA for public joint stock companies and the MOE for private joint stock companies, with a statement containing information about the relevant party, details of the transaction, and the nature and extent of the relevant party's benefit from the transaction. Such disclosure requirements align with the SCA's existing related party transaction rules under the corporate governance regulations. So this addition to the commercial company law does not present a practical change for the public joint stock companies. In addition to the expansion of the related party transaction requirements, the definition of related party has been removed from the commercial companies law. This provides the relevant authorities, that is the SCA and MOE, with an opportunity to redefine existing definition of what constitutes a related party under the governance rules, which previously have been based on the CCL's existing definition. The SCA definition of related parties covers directors, officers, employees, and affiliated companies. When it comes to financial assistance and the joint stock companies, the key changes to the financial assistance prohibition include the addition of 2 exemptions. The first one relates to the underwriters who, pursuant to the underwriting agreement, agree to purchase any unsubscribed shares to support UAE entities undertaking an IPO. This is a helpful clarification and supports prior market thinking that this activity fell outside the intended scope of the financial assistance prohibition. The second exemption relates to a carve-out for entities licensed by the central bank that provide loans to any person to enable them to hold any securities issued by such companies, provided such loans are given in the ordinary course of business and do not contain any preferential conditions. This is a helpful exemption when considering structuring options that include UAE entities carrying out banking and lending activities. It remains to be seen whether the case that the financial assistance prohibition will carry over to the LLCs or not. Loans to the directors and for the JSCs, the amendment law formalizes the exemption for loans to directors by entities regulated by the central bank. Shortly after the enactment of the CCL in 2015, the central bank issued a notice to the banks providing for this exemption, but there was a question mark over the central bank's authority to issue an exemption to what was a blanket prohibition under the CCL. This change is therefore helpful and clarifies the position. As an aside, it still remains unclear whether this prohibition on loans to directors carries over to the limited liability companies. Perhaps the cabinet resolution to be issued under Article 1042 will finally clarify this point. Resolution 272 was silent on it. From a legal perspective, we do advise people to be mindful of good corporate governance and think about these aspects quite carefully. When it comes to minority shareholder protection, although there has been little precedent for minority shareholder action in the UAE, the amendment law does set out a number of provisions that increase minority shareholder protection. This includes a lower threshold of 10%, by which a shareholder can request the board to hold a general meeting. A further boost to minority shareholder protection includes the ability of shareholders owning 5% or more of the company's share capital as opposed to the previous threshold of 10%, to add items to the agenda of a General Assembly meeting. Alongside the potential board composition changes under Article 151, the decree law removes the requirement for 2/3 of the directors of joint stock companies to be shareholders of the company. When it comes to directors' duties, the law has also expanded the directors' duties to the company's executive management. Executive management is defined broadly and includes the general manager, CEO, or the executive chairman of the company, their deputies, everyone in high executive position, executive management officers, and those appointed to the position personally by the board of directors. The concept of striking off a director has also been introduced, where an individual may be prohibited from acting as a director for a minimum of 3 years, where there is a final judgment finding that director to be in breach of his or her duties. There were no strike-off provisions under the commercial companies laws prior to these changes, although the UAE bankruptcy regime did include this concept. When a joint stock company loses, when the joint stock company losses reach 50% of its share capital, the board has an obligation, among others, to call a General Assembly meeting so that the shareholders may decide by way of a special resolution whether to continue or wind up the company. The decree law sets further procedural steps that the director must follow up after calling on the General Assembly. These include providing the board with up to 30 days from the date of invitation to convene the general meeting. This is, you will note, longer than the 21-day time limit for convening a general meeting. Requiring the board, where the recommendation is to continue the company, to include a restructuring plan and auditor's report with the invitation to convene the meeting. The restructuring plan attached to the invitation must include a feasibility study, plan of debt settlement, and a schedule for completing the restructuring. It does include requiring the board, where the recommendation is to liquidate the company, to include an auditor's report, company liquidation plan, and schedule to be approved by the board of directors of the company and its financial consultant, and nominate one or more liquidators as approved by the authority. In the event of a restructuring recommendation being implemented, the board must keep the authority, that is the SCA with respect to the public joint stock companies and MOE with respect to the private joint stock companies, updated on progress of any restructuring plan on a rolling 3-month basis. The relevant authority must also approve the appointment of and has the right to remove the financial consultant that will assist the preparation and implementation of the restructuring plan. We will not know the full extent to which the foreign ownership restrictions will continue to affect UAE businesses until this additional legislation is published and the local authorities at an emirate level start to implement the new rules in practice. There will be some time before the companies will have certainty about the options available to them. In the meantime, the LLC should review the terms of any nominee arrangement they have in place, including due dates for payments under them, and whether there are any provisions which facilitate or restrict termination of those arrangements or a transfer of the shares. On a termination of nominee arrangements, the company would remain an LLC. However, its name will require a suffix to denote it is a single shareholder company. A conversion requires a new memorandum of association in form appropriate for a sole shareholder. As discussed, there is to be a new cabinet decision regarding how single shareholder LLCs are to be incorporated and managed. In light of the changes, companies will need to review the constitutional document and consider what changes will be required and or preferred. In particular, the increase of the notice period for calling an AGM to 21 days will likely need to be updated in both the LLCs and the joint stock companies' constitutional documents. Whereas the LLCs will also need to give consideration to the amended quorum requirements and dispute resolution mechanism. Under Article 4 of the decree law, companies are required to adjust their positions within 1 year of the effective date of 2nd January 2021, that is by 2nd of January 2022, subject to this period being extended by cabinet resolution. Currently, as the law stands, a failure to do so will result in the company being deemed to be dissolved. A similar provision was contained in the original Commercial Companies Law in 2015, but in practice, 18 months after its introduction, the Ministry of Economy had issued Resolution 694 of 2016 to state that the existing companies were considered to have adjusted their position to the extent that they complied with the new law, without needing to take positive steps to amend the constitution. It remains to be seen if the government will take the same course of action this time. It is important to note in this context, there is a daily default fine of 100 dirhams for failure to adjust position. Although this is a reduction against 2,000 per day under the previous regime. Moving on to the UAE bankruptcy law, which I'm sure you would have been consulted by your clients from time to time. Federal Decree Law number 9 of 2016 on bankruptcy came into force on 29th of December 2016, overhauling the UAE's previously rather outdated insolvency regime, which was set out in Chapter 5 of the Commercial Code. The Commercial Code provisions applied only to commercial traders. The Law number 9 of 2016 applies more widely, covering companies governed by the UAE Commercial Companies Law, most free zone companies, traders, which could potentially include branches of foreign companies established in the UAE, civil companies conducting professional businesses. There are still some carve-outs, in particular for companies in the financial free zones, for example, the DIFC and the ADGM, which have their own insolvency regulations. The test of bankruptcy under the Commercial Code was solely based on cash flow, with the ability of a creditor to initiate bankruptcy proceedings triggered by a payment default of any magnitude. The law introduced a new balance sheet test of insolvency, which applies where the assets of the debtors are insufficient to cover its current liabilities. The cash flow test was also refined from a creditor's perspective. A creditor or a group of creditors may only initiate bankruptcy proceedings where they hold debts of at least 100,000 dirhams and have issued a written demand for repayment, which has not been satisfied within 30 UAE business days. This includes secured creditors to the extent that debts are not covered by the secured assets. That is, a secured creditor may commence a bankruptcy action in respect of the difference between the amount covered by security and the total amount due and owing to it where there is a security shortfall. Under the Commercial Code, a trader which was unable to pay its debts was required to apply to be declared bankrupt within 30 days. Failure to do so constituted the criminal offense of bankruptcy by default, resulting in fines and potential imprisonment. Although not actively prosecuted, the risk of imprisonment was generally considered likely to encourage a business owner in financial difficulty to abscond or even expedite bankruptcy rather than attempt to restructure the business. One of the key changes under the law was to decriminalize this behavior. A debtor which fails to repay due debt or which is insolvent on a balance sheet basis for over 30 UAE business days is required to initiate bankruptcy procedures under Article 68. Failure to do so, however, is no longer a criminal offense. Under the law, there are two potential options which may be available to a business in financial difficulties in the UAE. The first one is a protective composition proceedings, which is a rescue process for companies which are in distress but are not yet insolvent within the meaning of law. The second one is a bankruptcy proceeding, which can take two forms. Restructuring and bankruptcy, which is a rescue process for a company which is insolvent within the meaning of the law, or a liquidation, that is a terminal liquidation process in respect of the assets of the companies are monetized and distributed to creditors in the prescribed order of priority. What about bounce checks? Under the UAE Penal Code, criminal liability attaches to a person who writes a check in favor of a third party without sufficient funds to honor the payment, as well as for withdrawing funds resulting in a check being dishonored. In the context of a company, this liability generally attaches to the individual writing the check on behalf of the corporate entity. However, the offense may be remedied by payment of the debt at any time, including after the criminal court has passed the judgment. Under the bankruptcy law, criminal proceedings for such an offense will be suspended if the check was written in the period before the company enters PCP or a court-ordered RIB. After the terms of the repayment scheme have been approved by the court and creditors, the debt which is the subject of the check may be settled under those terms and the consequent criminal offense remedied. However, the potential criminal liability has not been fully removed by the bankruptcy law. If the company's financial situation deteriorates to the extent that the company is wound up in a bankruptcy process, criminal proceedings may not be suspended. This means that the directors and managers of the companies in the most severe financial trouble remain at risk of penal sanctions for dishonored checks. In practice, directors and managers may find it difficult to assess when writing checks early on in a company's decline the likelihood of finding it being ordered by the court in the future. Please do note that in Dubai, bounce check cases may be heard by public prosecutor rather than proceeding to trial, in which case, in the event of an alleged perpetrator being found guilty, the public prosecutor will issue a penal order levying a fixed fine of 2,000 dirhams if the face value of the bounce check is less than or equal to 50,000, a fine of 5,000 if the value of the bounce checks is between 50,001 and 100,000, and 10,000 dirhams if the face value of the bounce check is between 100,001 and 200,000. In 2020, the Commercial Code was amended by Federal Decree Law number 14 to insert offenses relating to non-payment checks as part of measures to decriminalize the writing of bounce checks more generally. These provisions will come into force with effect on 2nd of January 2022. The Penal Code provision just described will be replaced from this date. Under the new Commercial Code provisions, the offenses are focused on deliberate acts to avoid payment under a check, such as refusing in bad faith to honor a check where sufficient funds are available, or untruthfully declaring insufficient funds. With respect to personal liability of directors and managers of UAE companies, Article 644, base subclause 1, states that where the offense relates to a check to be drawn on the account of a legal person, the person in charge of the management of that legal person will only be subject to sanctions if he or she is proven to have been aware of the offense, has committed it in his own interest or in the interest of a third party. If no natural person is held accountable for the offense, the fine levied on the legal person may be up to 5 times the amount of fine specified in the law, and the entity's commercial license may be suspended for up to 6 months with the threat of dissolution of a repeat offense. A key change which was recently implemented to the bankruptcy law was a power given to the UAE cabinet to declare an emergency financial crisis. An emergency financial crisis is defined as a general situation that affects trade or investment in the country, such as a pandemic, natural or environmental disaster, war, etc. At the time of announcing the changes to the bankruptcy law, an EFC was not declared. However, we expected that such an announcement was imminent and that it would likely have retrospective effect to run in parallel to the pandemic. As predicted, on 10th of January 2021, the UAE cabinet announced the existence of an EFC and declared the EFC as having started on 1st of April 2020 and continuing until at least 31st of July 2021. What does this mean for debtors and creditors? In summary, during an emergency financial crisis, debtors are not required to file for bankruptcy if they have failed to pay their debts within 30 days due to this crisis, and it is not clear whether the debtor will have to satisfy the court that the failure to pay was due to the emergency financial crisis and whether disputes will arise on this particular issue. Also, during an EFC, the debtors can still file for bankruptcy, and the court may elect not to appoint a trustee in the proceedings if the debtor proves that the disruption to the business was caused by the EFC. The court will not take any precautionary measures against the debtor's assets which are essential for the operation of the debtor's business during the financial crisis. Creditors cannot file, and the court will not accept bankruptcy applications against debtors during the EFC. Settlement with the creditors, which only applies to debtor filings. If the bankruptcy is accepted by the court, the debtor may request 40 business days to negotiate settlement with creditors. If approved by the court, this shall be published and include an invitation to creditors to negotiate settlement within 20 business days. The settlement period offered to creditors shall not exceed 12 months. If the settlement is reached with the creditors with 2/3 of the debts, this settlement shall be binding on all creditors, even those who did not participate. The settlement negotiation must be in writing and approved by the court. Existing bankruptcy proceedings filed before the declaration of the financial crisis, that is, those filed before 1st of April 2020 will continue, although the court can double the time period set under the bankruptcy law for these proceedings. What is, however, slightly unclear at this stage is how the court will interpret the effect of EFC declaration on claims filed after 1st of April 2020 and before the issuance of law on 10th of January 2021. That is, those filed prior to the actual declaration of an EFC, but after the 1st April 2020 date, from which the EFC has been declared to have been existed. It would seem perhaps procedurally unfair for the creditors in that position to have bankruptcy actions stayed or dismissed retrospectively, especially where various steps may have been taken and costs incurred in such proceedings already that affect party status and rights. So the better interpretation, we think, may be that such actions are unaffected and the impact on bankruptcy actions will operate only to those filed after 10th of January 2021. This is something we will observe in practice on active cases for the interpretation that is applied in the coming weeks. Directors' liability will not arise where those directors pay unpaid salaries of employees, excluding allowances, pay rises, and other contingent payments out of the company funds. New money will be available to debtors during a financial crisis. Debtors may obtain new financing, secured and unsecured, with court approval, which will have priority over existing debts. Please note that the creditors can still take legal action to pursue the debts. While ultimately the threat of commencing bankruptcy proceedings may not be available to creditors during a financial crisis, it is important to appreciate that creditors can still pursue recovery of the debts through civil remedies in the UAE courts, regardless of the existence of an emergency financial crisis. For example, creditors remain entitled to apply for payment orders, precautionary attachments, and they may also pursue standard civil claims for debt recovery as a money judgment. Next part of it, I will pass on to my partner, Matt Shanahan, who is going to cover the economic substance regulations. Thank you very much. I look forward to your questions toward the end of this presentation.
Thank you, Mr. Abhimanyu Jalan, for addressing our members and explaining various articles in detail. I think we need to wait and watch for further clarification on various issues, like you mentioned about 51-49% ownership, then auditor's term increased to 6 years. And thank you very much for highlighting the provisions of the bankruptcy law as well as emergency financial crisis, which was new for me as well. I wasn't aware. Thank you very much. Big round of applause for our speaker, Abhimanyu Jalan. Thank you, sir. And now I request our ExCom member, Mr. Manu Nair, to introduce our next speaker, Mr. Matthew Sanahan. Over to you, Manu.
Thank you so much, CA Harikrishnan Raghavat. Good afternoon, fellow members and guests. Our next speaker is also an expert in the law and an eminent speaker. He is a financial services regulatory lawyer, head of regulatory and investigations practice, partner at Clyde & Co. in Dubai. He is none other than Mr. Matthew Sanahan. Mr. Matthew specializes in advisory and contentious financial service regulation, advising banks, securities firms, other financial institutions, and public sector bodies on all aspects of financial services regulation, including market abuse, fintech, anti-money laundering, financial crime, and legislative drafting. He also advises clients on managing regulatory relationships, navigating complex investigations and enforcement actions, complex commercial disputes, handling clients' complaints, internal investigations, and crisis management. He has more than 20 years of experience in this field. Today, Mr. Matthew will be highlighting the major changes or updates on 3 regulations: economic substance regulation, beneficial ownership procedure, that is ultimate UBO, and AML, anti-money laundering. All the 3 topics are in my favorites list. To hear from the expert, please help me to welcome Mr. Matthew.
Thank you very much for that introduction. So I know you've already said a fair amount about my practice, but I'll just add a couple of things before I begin. First of all, thank you very much for inviting me today. It's a real pleasure to talk to your members. And I'm looking forward to discussing those 3 very interesting topics: economic substance, UBO, so ultimate beneficial owner regulations, and AML, 3 subjects which are fairly closely connected, as I'll hope to explain to you as my presentation develops. But a little bit more about me. First of all, I am a partner at Clyde & Co., as you'll have seen, and I head Clyde & Co.'s Middle East regulatory investigations and compliance practice. I've been in the UAE for about 12 years now. Prior to coming to the UAE, I was a regulator in the United Kingdom working for the Financial Conduct Authority. And prior to going into private practice in 2015, I was a regulator in Dubai. I was a senior lawyer at the Dubai Financial Services Authority in the DIFC. So most of my work involves advising on regulatory matters and financial crime, including acting for accountants and auditors. I represent clients who generally face regulatory investigations, but I do some work for audit firms in this area, although my colleague, John Lewis, who some of you may have already met, does most of our professional services liability work, but I assist on the regulatory aspects of it. And in the UAE, regulator would be the Ministry of Economy. So I'll start with a relatively brief run through of the UAE's economic substance regulations. And my first slide I put up is as a news item from Bloomberg Television in March 2019, when it was announced that the UAE was added to the EU tax havens blacklist. And the reason I've started with this slide is really to sort of give some background. Being a regulator, I usually think about laws in terms of the policy intentions behind those laws. So why do we have economic substance regulations? And I do apologize in advance for those of you who are, relatively speaking, experts in this area. So really the UAE's economic substance regulations were introduced in part because the UAE was added to an this EU blacklist. But that was only part of the reason. The main reason was that it was to align the UAE regulations with the OECD's base erosion and profit shifting directives, or BEPS, as I'm sure some of you have heard of. And it's really to demonstrate actual economic activity of legal persons, of companies, and ensuring that companies based in the UAE are not being used simply for tax purposes. In other words, that I think the view in the EU and other jurisdictions was that the UAE was often being used as a jurisdiction purely because of its zero, or not always zero, but largely zero tax framework, and that companies were parking their income generating activities here, but without having any real substance. So the idea of the regulations is to ensure that companies within certain sectors can demonstrate that they do actually have economic substance in the UAE. And I'm sure many of you will be aware of some of the types of activities and concerns that that the EU and other countries have expressed about the UAE. So a good example would be sort of the RAC type company setup, but companies in commercial free zones generally, which are set up purely to benefit from the UAE's fairly generous tax regime. And I've worked, as I said, I work a lot on investigations of companies and financial crime, and I've worked on a number of investigations in the UAE in the past where there was significant evidence of profit shifting. And in a period right up to 2018, I would say, a large number of, this is in terms of investigations I'd seen, identifying a large number of Indian companies in particular who were making circular payments amongst group companies without any apparent rationale for them. Another one that would sometimes come up in investigations, not necessarily investigations connected to a particular tax issue, but just generally within an investigation are these Mauritian tax schemes, and also and possibly why the EU was keen for the UAE to bring its regulations up to international standards. A lot of EU individual money parked in companies in UAE commercial free zones without any sort of rationale for that money being based in the UAE. So the end result was the economic substance regulations. So they were introduced in 2019. And the purpose of as I already said, was to ensure that the UAE complies with the OECD standards. It only applies to certain categories of business, but those businesses have to demonstrate that they undertake what we call substantive economic activity in the UAE. Those sectors are banking, insurance, investment fund management, financial leasing. It says finance leasing, but the actual definition is both finance companies and leasing companies. Headquarter companies, shipping. I think there's always been an issue around shipping companies and where they're located and why they're located in certain jurisdictions. Holding companies, holding company structures, intellectual company operations, and distribution and service centers. And I think those of you, I mean, you'll all be very experienced accountants. You'll all know probably the reason why those types of businesses were targeted, because they're the types of companies which can be used to abuse tax systems, often due to, for example, with distribution and service centers having fairly broad definition of what those types of companies do, and therefore people being able to park income in these sort of fairly vague descriptions of companies in the UAE, and what you will notice as well is that a lot of the categories are in the financial services sector. So that's another area where there's been abuse for tax reasons. So that sector gets hit probably harder than any other under these new economic substance regulations. So the rules require that companies demonstrate what's called core income generating activities, and the regulations do provide examples of those. They must also show that management and control exists within the UAE. In other words, that decisions must be made in the UAE. They need to show that they have employees here. I'll come to that in a second about outsourcing. Outsourcing is permitted, but only in certain circumstances. They need to show expenditure, and they need to show assets. So this is how the economic substance regulations capture companies and seek to place some controls over sort of parking of profits in particular jurisdictions, because if you do that, you'll need to show that you've got core income generating activities and show exactly how you've generated that income. As I mentioned, outsourcing of employees is possible, but under the regulations, that outsourcing must be to, if it's one of the core income generating activities, the outsourcing of employees must be in the UAE. You can't outsource the employees overseas if it's in relation to the core income generating activity. Expenditure, so outsourcing of expenditure and assets is also permitted, as I said, the subject to conditions. There are reduced requirements for certain types of holding companies for the simple reason that it's fairly typical for holding company structures to be created, and generally holding companies will find it difficult to demonstrate core income generating activities when most of their income is usually generated from some sort of dividend income. But the most onerous part of the regime is for high-risk intellectual property businesses, where obviously there's the greatest risk of abuse. There is a reporting obligation. It's annual. There's an annual notification to be made within 6 months of the financial year end. And then there's an annual report which must be submitted within 12 months of the year end, to the extent that any core income generating activities did occur and income was generated. But the reporting obligation applies to the activity that was conducted, the income, the amount and the types of expenses and assets, and the number of employees. And there's also a declaration of compliance. Now, you should also be aware that administrative fines can be imposed. I think for first offenses, I believe it's 50,000 dirhams. The second offenses, it increases almost tenfold to 400,000 dirhams. And just for any of you who are, and this is just from information I've gathered recently, if any of you are based or do business in the DIFC, the DIFC has started auditing companies for compliance with the economic substance regulations. So this is not just a case of of just reporting. That there will be enforcement of the regulations, and particularly those companies where, for example, the DIFC considers that if they haven't made a notification or a report, they perhaps should have done. And we've seen very recently an example of a company who were being audited in the DIFC. So now, just so one interesting thing is at the end of last year, the economic substance regulations were actually updated by a cabinet resolution. That was in August 2020. A lot of companies had already prepared. Some of them had filed notifications. And when they updated the regulations, some companies had to reconsider some of their initial notification. And so that's been a little challenging for the sector. And they've also had to go and get additional legal advice. But there's now, what's been the most useful thing though about the update 2020 is there's been some revised Ministry of Finance guidance which was issued. And for those of you who are struggling with the economic substance regulations, I recommend that you take a look at those, look at that guidance. And it's very helpful. By UAE standards, it's very detailed, and it's essentially in a question and answer format. And it's fairly easy to read. It doesn't resolve all the issues, but it goes a long way to clarifying some of the most important issues that companies need to think about in the context of economic substance. And although I know law firms have been doing a lot of work to advise clients on compliance with the economic substance regulations, I'm also aware that the accounting and audit industry has also been fairly active in this space. But the key changes that were introduced by the updated cabinet resolution in August last year, they've tightened up the definition of a licensee, just for clarity, because the previous definition was a little bit loose and it wasn't clear who should or shouldn't be caught. They've clarified the issue of the treatment of branches. So in effect, branches are only caught if they're not taxed abroad on their income. So in other words, if you're a branch and you're subject to tax in your home state or your head office jurisdiction, then you'd be exempt. It sets out a list of exempt entities to include, for example, investment funds. I think prior to that clarification, it was very difficult for investment funds to make proper reports because most investment funds don't have employees and they find it difficult to show economic substance. Therefore, they were exempted, and really the focus for the regulations is now on the investment manager. And then there are certain other exemptions provided, including overseas tax residents. They made changes to the relevant activities, including the concept of a distribution and service center business. This was proving to be quite challenging because the term itself is, potential of, you can interpret it very widely, and so they sort of gave some reasonable guidance on what that means. But the scope of that is potentially very, very wide still. They also introduced a new notification and reporting via a Ministry of Finance portal. And the FTA was appointed as the National Assessing Authority. I would say to date from, and I'm sure some of you have first-hand experience as well, but to date, the FTA, in my experience, has been, at least by UAE standards, fairly aggressive in its enforcement of its laws. I say that because, in my experience, regulators in the UAE are generally not enforcement-led. They tend to be complaint-led. In other words, when they receive a complaint, they act on it. But the FTA certainly is a very proactive regulator, and it can be very aggressive by local standards. And the new regulations increase the penalties for breaches. So what was the outcome? Well, the outcome was fairly positive in terms of the international sort of reaction to the UAE implementing the economic substance regulations. The EU, in fact, removed removed the UAE from the tax havens list only a few months after they implemented their regulations. So that's a positive sign. I think in a way that they were put on the the blacklist by the EU more as a sort of way of incentivizing them to implement the regulations, because the EU was actually aware already that that the UAE was going to implement something. I think they were just a bit concerned about timing, so they put them on the list to encourage them to move a bit faster. But it does show that these types of blacklists they do work, and they work very well. So having touched on economic substance, which is was implemented primarily to deal with tax avoidance issues, I'll now discuss relatively quickly the UAE's UBO regime, and UBO being the ultimate beneficial owner regime. So there was a cabinet decision 58 of 2020 implemented a regime for companies who are licensed in the UAE to report on a number of matters, including having a register of beneficial owners and registered partners and shareholders. This was very much new to the UAE. It's caused, I've advised fairly extensively on the UBO regime. It's caused some, I wouldn't say upset, but it's really sort of slightly rocked the boat in terms of the way people do business here. The idea of confidentiality in commercial enterprises is fairly well established in the UAE. So asking companies here to declare who their ultimate owners are, I think in relative terms, is a fairly new concept. But again, this was implemented in order for the UAE to demonstrate that it was complying with its international obligations, and is connected to UAE's regime on anti-money laundering. The issue with anti-money laundering is, as most of you will know, is anti-money laundering rules require companies to look through and know who they're doing business with. And the problem in the UAE was there's no register of ultimate beneficial owners, so it was proving very difficult to know who a company was ultimately dealing with when they engage with counterparties. So this new regulation makes it much easier. It also, more than anything, it makes it easier for the authorities to obtain this information. And I think that overall is the real purpose of the UBO regulations. Ultimately, the UAE, as an international player on the sort of regulatory, international regulatory standards, receives regular requests from foreign regulators to provide information about individuals and companies within the UAE. And part of the problem that the UAE authorities had was they didn't know who was sitting behind these companies that were based in the UAE. So if they received a request for information, say from the Indian authorities about a company based in say, DMCC, it was proving very difficult for them to provide information to the Indian authorities about who the ultimate owners of these companies were. And the UAE faced criticism for that. So therefore, from going since 2020 and earlier in other legal jurisdictions in the UAE, I know the DIFC UBO regime started a bit earlier, but since this regime started, companies have to know who their ultimate beneficial owners are, and they're required to take reasonable procedures to obtain and maintain the UBO data. In other words, it's not just a one-off declaration. Companies need to know on an ongoing basis who owns them ultimately. So that has to be, and therefore the company has to keep a register, and it must provide the information to the licensing authorities. So the licensing authorities will depend where you're established in the UAE. So it's usually will be the DED, or if you're in a free zone, the free zone authority. As I mentioned already, the DIFC and the ADGM have their own similar regimes, which they've actually been enforcing for some time now. There are certain exemptions that apply, for example, for listed companies, provided that the listed company discloses on some sort of register who the UBOs are. Or, the reason for that is that public listed companies, there's much more transparency about who owns them. So why is it important? I think in particular the DD and many of the free zones generally will not approve any transactions that the company undertakes, for example, renewal of commercial licenses, unless the UBO information has been provided. So we do know that Abu Dhabi isn't yet blocking transactions, but we expect them to follow suit soon. And what's the relevance for the accounting and audit community? I think the most important impact is that the relevant registrars now have a power to request information and can ask auditors and accountants to attend at a meeting and provide it. And it has to be provided. And there's a very limited exemption, but it's really for sort of privileged information, and it won't usually apply for accountants and auditors. And very importantly, so if you get a request for information to provide information, then that information may be shared with a foreign regulator. So just be aware of that. So moving on to what is really just an update on AML developments in the UAE. I think by now, most, if not all of you, will be very familiar with anti-money laundering regimes. They're just a part of everyday life now. But there have been some very interesting recent developments in the UAE that some of you may not be aware of. And I'm starting with a screenshot, a picture that was in I believe it was in the Gulf News recently. And some of you may recognize this young man, but this is someone who's known by the nickname Hush Puppy, and he was arrested by the Dubai police as part of a very high-profile recent raid. It was called Operation Fox Hunt 2, which is a very nice operation name. Fox Hunt 1 was another raid they undertook where they arrested 8 people. But in Fox Hunt 2, they arrested Hush Puppy and 11 other individuals involved in an international financial crime network. And it was done very publicly to show that the UAE is enforcing its anti-money laundering regime. I believe the Dubai police may have live streamed part of the arrest. And if they didn't live stream, I may have misremembered that. They certainly made the video available fairly widely. And it's an indication that Dubai is dealing with the fairly widespread criticism that it's a bit of a safe harbor, a safe haven for money launderers who can come to the UAE and live in luxury, spending their illegally gained money without fear of arrest. And I think the idea here was to say, well, actually, that's no longer the case. And then that was June 2020, during not long after the lockdown ended. And more recently, in January this year, the Central Bank of the UAE fined 11 UAE banks a total of 45 million dirhams for breaches of anti-money laundering rules. Now, interestingly, and this is not uncommon in the UAE, but in fact, I would say it's the norm. Those 11 banks were not named, so we never got to find out exactly who was fined and who's been breaking the rules. But I have seen the list, and I can say that most of them are sort of second and third tier banks. None of the large, well, very few of the large household names that you'll all be aware of were on that list. But nonetheless, this, I mean, I've been in the country for 12 years. I've never seen anything like this. The sort of the nature of this very public nature of this, and the level of fines, which are much more similar, albeit smaller, but still similar to fines that banks might face in other jurisdictions, like in the UK or the US. So another example of the UAE taking action on anti-money laundering. Then in February, the UAE Central Bank fined a single individual 600,000 dirhams for breaches of the anti-money laundering law. Again, this is fairly unprecedented. And since I've been in this country, I've never seen, certainly not publicly. I'm sure, there have been fines imposed by the regulators for anti-money laundering breaches, but they've never made it quite so public. So it is very much a trend. And then in March, it was published in newspapers, tough new fines, and this was all over the UAE dailies. As the UAE toughens regulations on money laundering, you can be now be fined up to 5 million dirhams. And interestingly, in February, a UK man, I've tried to keep him fairly anonymous by only showing the top half of his head, but a UK man, well, actually, I haven't done a very good job because his name's there, but a UK man was extradited from the UAE who was charged in the UK over the supply of drugs and firearms. So effectively, he was extradited under the extradition treaty with the UK in relation to his money laundering, in connection with his money laundering, and he was in the UAE avoiding prosecution in the UK. And again, that on its own, it may not sound like a huge story, but these types of extraditions are fairly rare. It's quite difficult for the UK authorities and other authorities in other countries to extradite individuals from the UAE. But again, this is another example of the authorities ramping up their enforcement measures against money launderers. And why has all this happened? So the main reason for this is to do with, it goes back a few years actually. In 2018, the UAE was subject to what's called a mutual evaluation by the Financial Action Task Force, which is the international standard setter for anti-money laundering regulations. That mutual evaluation, which is where a team from the Financial Action Task Force is generally referred to as FATF, but they sent a team over to the UAE to come and assess the UAE's anti-money laundering regime, whether it was in compliance with their standards, and then assess whether it was an effective regime. And by effective, they mean not only do you have rules and regulations about anti-money laundering, but you actually supervise for those and you enforce on them. The outcome of that mutual assessment was a mixed picture. The FATF in its report was fairly muted. They weren't too openly critical of the UAE, but if you read between the lines, what they said was that UAE, although it had a very good legal regime, it was not properly implementing its own laws. And that's the first thing. The second thing was that it hadn't properly implemented laws within certain sectors, and primarily by that it meant in the non-financial sector. And thirdly, it wasn't prosecuting enough in relation to anti-money laundering, in relation to money laundering offenses for a country, and they said particularly Dubai, which has a very high profile in terms of money laundering. And then finally, they said that the UAE was not cooperating with international requests for information about individuals and companies connected with money laundering. And I touched on this a moment ago. One of the issues was that often requests for information from regulators either were taking a long time to be dealt with, but also there was a real problem with the quality of information that was being sent back. And part of the fix for that was for the UAE to implement the UBO regime. So that's essentially what's behind all this recent activity. And the reason the activity has intensified is because the FATF, the Financial Action Task Force, has said, and they published their results in early 2020, I believe it was January or February. They said if the UAE doesn't clean up its act and start to demonstrate effectiveness of this regime by actually enforcing it, then there was a risk that the UAE will be put on what's called the FATF grey list. And being put on the FATF grey list is not something that any country wants. It can cause many, many difficulties for financial flows in and out of that country. It makes it difficult for companies overseas to do business with individuals and companies from that jurisdiction. So one thing that the UAE does not want is to end up on the FATF grey list. That is crucial. Dubai it considers itself, and in fact, indeed is a big commercial center. UAE is a big commercial center in the Middle East, and anything which will risk denting its status as a significant commercial center is obviously important for the UAE to avoid at all costs. And this explains the fairly intense developments in terms of the prosecution of and the enforcement of the anti-money laundering rules. And I'll touch back on that in a second. But certainly, that's why we're seeing so much in the press at the moment, if you indeed read this stuff. But what does it mean for you? The 2019, so the main law for anti-money laundering, main anti-money laundering law is a 2018 law which sets out the key provisions on anti-money laundering and the requirement to submit what are called suspicious transaction reports. There are also some regulations which were published in 2019, which have a bit more detail in them, the implementing regulations, and they set out various definitions, including the definition of a designated non-financial business and profession. And this was one area that the FATF said UAE hadn't implemented very well. It said that although the banks and the financial sector generally was required to comply with detailed anti-money laundering regulations, it said outside that sector, the implementation was fairly mixed. In the DIFC, if any of you are based in the DIFC, you've been subject to regulation for many years now. But outside the DIFC, it wasn't clear, first of all, whether any rules applied. And secondly, if there were rules applying, it wasn't clear which was the authority that was responsible for implementing them. And this was, particularly in sectors such as real estate, but even accountants, auditors, and company service providers. So, so what is a designated non-financial business or profession? The regulations define it to include a number of different sectors, but notably, it includes independent accountants. Now, it's defined as only applying in the context of certain types of transactions, but as the definition says, preparing, conducting, or executing financial transactions for their customers in respect of certain types of activities. Now, the interpretation of that is generally quite wide. So although on paper it may look as if you may not be caught, in fact, I know certain of the relevant authorities are taking a fairly broad interpretation of what that means. And in fact, if you're in the DIFC or the ADGM, the application is that effectively, if you're an auditor or an accountant in those financial free zones, you have to register as a DNFBP and you have to comply with the regulations. So and that's why it's very important for the sector to understand what the scope is, because they will be enforcing now. And if you're required to register and you haven't, there are likely to be penalties applied. So bear that in mind. And even for those, so for those of you in in the accounting sector, if you're working in an accounting business, that think that you don't undertake any of those transactions. It also applies to what's called providers of corporate services and trusts. So I've spoken to clients in this sector, in the accounting sector and audit sector, who have sort of, well, not so much audit sector, in the accounting sector, who have sort of additional services they provide to clients. And that's where they need to be careful, because the concept of corporate services is being defined quite widely, even though on paper it only applies to specified activities, which you can see on the screen there in front of you. So just worth bearing that in mind. It's the application is fairly broad. So moving on. So what do the rules require? What do they require you to do? Now, I appreciate some of you may be very familiar with all these rules. So for those of you, I do apologize, but I think it's still worth doing a quick sort of overview of what the main rules require. It's one area I advise extensively on anti-money laundering matters. I drafted the regime in the DIFC when I was working at the regulator, and that same regime has been copied over into the ADGM. So I think having that first-hand knowledge has been quite helpful on the advisory side. But I think there's often a lot of confusion about what firms need to do, and exactly what the rules mean. The biggest challenge has been caused by the fact that up till now, the UAE's had what's called very much a tick box approach to AML matters, where you just have to collect certain information, make sure you got it, and then keep it on file. So it's been a fairly, I mean, it's strict regime in the sense that checklist of items that have to be collected is fairly long, but a very easy regime, because the people have always taken comfort from the fact that as long as they've got the list of things they need to obtain about their customers, then they feel that they've been in compliance with the law. But in fact, the Ministry of Economy has published very detailed guidelines for DNFBPs and published supplemental guidance for the auditors. In fact, that supplemental guidance is useful, whether or not you're an auditor. It's got some very good examples of the types of activities and that you need to be looking out for, and some typologies. And those examples they provide are actually based on real life money laundering events. So it's certainly worth a look at that. But what a lot of my clients who are relatively new to to these regulations don't realize is that, in fact, the first thing that they need to do is understand what the risk-based approach is, and that's the challenge in a country where to date you generally adopted this tick box approach, where you obtain these 5, 10 items on a customer, and then you've complied with the rules, which was what the old regime was really about. The risk-based approach is about tailoring the types of the rules and the activities under those rules to the risk rating of your customer. And so what the rules generally require is that you make an assessment of the risk of your customers and an assessment of the risk of your business, and then understand what the risks are. So in terms of risk factors, they talk about customer risk, geographic risk, product service risk, and channel related risk. And by channel-related risk, it means that the sort of different medium which that particular industry uses, whether it's online, whether it's whether it's related to a particular so it's offline, online, but also if it's related to a particular sector. So you really do have to, you've got a much more difficult job now, because you don't just have to understand or collect information about your customers. You have to understand your own business, understand what the risk factors are, and this is what you'll be assessed for in terms of compliance. So that risk assessment, you risk assess your business and your product, services, geography of your customers, etc. And then you have to then assess the individual customers according to those factors and understand and generally give them a rating. So most companies use a high, medium, or low. And then that's when, and after you've done that, that's when the hard work starts. So the next section in the regulations, the Ministry of Economy regulations is mitigation of money laundering risks. So, and that means undertaking what's called customer due diligence. This is what used to be, the sort of tick box thing where you just collect 10 things about your customers and that was it. But now you have, it's much more nuanced. It's much more, you have to effectively take an 80-20 approach. So you dedicate 80% of your effort to the 20% higher risk, highest risk clients. And you dedicate obviously 20% to the 80% others who are low risk. And that the point of that is that you shouldn't treat every customer the same. If you collect 10 bits of information and you do background checks on every single customer, you're wasting effort and resource where you should be placing a lot more effort into the high risk customers and less effort into the low risk customers, so that you're using your resources more effectively for anti-money laundering purposes. So there's a requirement, and we touched on this before, to collect beneficial owner information. It's not just good enough to know the company you're dealing with. You have to know who's behind it. You have to undertake ongoing monitoring. That in itself is a challenge, particularly depending which sector you're in, but it's about just being aware of the transactions that your customer's undertaking and monitoring those to ensure that there's nothing suspicious. You have to update CD on a fairly regular basis. I mean, generally most companies will do annually for high risk customers and then maybe once every couple of years for lower risk customers. And then there's something called enhanced customer due diligence. And that's where you have to carry out additional measures in relation to the highest risk customers. This is a real challenge, especially in this region. A lot of counterparties and customers are simply not used to providing information. This confidentiality is highly valued in this part of the world. And often I see clients, asking me about, well, the customer's acting suspiciously, they're not providing this information. But I think more often than not, it's simply that they're just not used to it, or they just don't see the value in providing it, given the service that they're requesting from that particular service provider. You have to identify PEPs, and PEPs are a special type of customer. PEPs is a politically exposed person. The definition is fairly broad under FATF, and it covers anyone who's connected to government, even those who've left government, who still have influence over government. But anyone in the government industry, if they're significant, if they're high enough up in a government department or something, needs to be treated as a PEP. When there's a PEP, additional requirements apply on top of enhanced due diligence, but all PEPs will generally be treated as high risk. Now, this in the UAE, this creates many, many challenges, because so many customers and counterparties that we deal with will have a PEP somewhere in their structure, because there are a lot of government-related entities in the UAE. A lot of us do business with them. And then when you look up to the UBOs or you look up to the senior management of those companies, you invariably will find someone who's connected to the government in some way. So that's often a challenge here. But it's something I think a lot of people are getting used to now. And then obviously there's looking at this 80-20 approach to AML, there's simplified customer due diligence, which is where you can undertake a less onerous form of customer due diligence if your client is sufficiently low risk. And that's what the risk-based approach is. You can do simplified CDD where the risks are genuinely lower. And then finally, in terms of mitigation, suspicious transaction reporting, and what helps with, I often get contacted by clients asking me whether a particular transaction is suspicious and what they need to be looking at. I think what really helps is just knowing the types of risks that exist, and those risks will vary from sector to sector. But there are many good sources on the internet that you can find. One of the best sources is actually FATF. FATF publishes, a huge amount of guidance about money laundering risks. And I recommend if this is an area that you're responsible for, or you're in senior management of your company, and you're concerned about the risks of non-compliance, something you need to point your compliance team to. They have a lot of guidance, a lot of real life examples. And I've been involved in so many investigations over the years that involve money laundering, and that it makes a huge difference to have done that work, because you then start to understand the complexities of money laundering, and it makes it much easier to identify it. And one of the common questions I ask, when I'm looking at these types of things, is where a transaction is unnecessarily complex and has layers and layers of different sort of companies involved. And the first question you ask yourself is, do they need all this to carry out this transaction? That's always a good question to ask. And there often will be reasons, genuine reasons why they're doing it a particular way, but in my experience, often there aren't. And as I mentioned, the Ministry of Economy guidance contains some very useful examples from around the world about particular sectors, and gives examples, real life examples of money laundering. So the last part of the rules, the Ministry of Economy rules, which apply to DNFPVs, are what's called administration and reporting. But the first thing that those rules deal with is something called governance. And I'm highlighting this because this is something, if you're senior member in a company that's a DNFPV, you need to be thinking about. So it requires the appointment of what they call a compliance officer. It's usually typically known as a money laundering reporting officer, or MLRO. It requires training. We usually recommend annual training, and we recommend giving training to all staff. But obviously, if that's maybe going a bit far for your particular organization, we recommend giving to all sort of client front-facing staff, because it's really about training as many people as possible within the company to understand what the risks are. And I always recommend giving, because one of the challenges with AML training is it can be quite, to put it kindly, it can be a little bit uninteresting. But I always try and encourage clients when they're doing training, or when I'm giving them training, I always try to give real life examples that are relevant to their sector. So people understand the types of things they might see. And it's easier to understand something by way of real examples, because those are the sort of examples you might identify in your business. But the thing that's really crucial is in respect of senior management responsibility. So this is in this part of the world anyway, it's unless you're in one of the financial free zones, it's quite a new development. In the DIFC and the ADGM, senior management responsibility has been there from the start, but now it applies in onshore UAE. And that means that if you're a senior management of a company, you're potentially at risk, not just of your company facing enforcement action, but if it's found that as a senior manager, you were, you didn't, for example, implement proper systems and controls to monitor money laundering, you could be personally liable, and you could be fined under the relevant regime. So that's something to bear in mind. Record keeping is obviously very important, but I need to go into that. And then one thing to remember is that the UAE anti-money laundering regulations don't just apply to money laundering, which in a nutshell is really about is about the proceeds of crime and the laundering of the proceeds of crime. It also applies to terrorist financing activities that you have to be aware of. And it applies, you need to also consider international sanctions. So that means, what does that mean? And that means looking at United Nations sanctions, US, EU, even UAE has a list of sanctions. They're a little bit difficult to find, but they've recently improved the sort of accessibility to the list of sanctioned entities and companies in the UAE. So that's made it a bit easier. But what I generally advise with things like sanctions and terrorist financing, lists of terrorists, is that people use a good third-party source. I mean, there's no substitute for Google. It's fantastic, but it's not going to catch everything. So there are certain very good third-party software providers who provide fantastic software which will keep up to date with sanctions and persons who are subject to sanctions. I mean, one of the most popular ones is WorldCheck, but there are several. And then just finally, I'll just say, I have seen a lot of examples of money laundering affecting the sort of accounting and the audit industry. I get fairly, I don't know if regular is the right word, but I do get calls from time to time, particularly in January, February, around audit time, asking for advice from auditors on suspicious transactions, and particular things like circular payments or sort of payments made to foreign companies, subsidiaries, or foreign officials, and that are disguised as other types of payments. Those are the sort of things which I regularly get asked about. But I also get asked about matters to do with even market abuse or odd transactions in listed company transactions. And so these are all things that affect your industry. Often a lot of DNFPBs say, well, we'll just rely on the financial institutions. They'll catch any suspicious transactions because generally they go through the banking system. But it's not, as accountants and auditors, you are pretty much as close as anybody to a company's financial transactions. I don't think probably anyone is closer. And so you're really in a very good position to be identifying money laundering. And just finishing off, I just setting out there the relevant guidelines for those of you who haven't seen it. This is the Ministry of Economy guidelines. And they've got this, as I say, this excellent supplemental guidance for auditors, which I'd recommend anyone to read, even non-auditors, if you're involved in that sector. And then finally, just a word of warning. The financial free zone regulators, that's the DFSA in the DIFC, that's the Dubai Financial Services Authority, and the Financial Services Regulatory Authority in the ADGM, both have very strong powers in relation to gather information. And I recently was assisting a client in the audit sector who are outside the DIS, outside the financial free zones. I got a call from them on a weekend saying they'd received a notice, and what should they do? They got a notice from the police, and the reason they got this notice is that the financial free zone regulators have powers are not just, they don't just have to exercise those powers in relation to financial free zone companies, so DIFC, ADGM companies. They can exercise some of those search powers and information gathering powers against any person located anywhere. As long as they're liaising with the local regulator, if it's onshore, they can get information. So there've been a number of examples I've dealt with recently where accounting firms have been contacted either through the local regulator or directly from the police in relation to requests for audit or accounting information in relation to DIFC companies who are involved in some sort of investigation. So just be aware, the authorities here are tough, they're getting tougher. And I don't think in the foreseeable future it's going to get any easier. In fact, it's probably just going to get harder. And part of the reason for that, and this is my last slide, I promise, is that recently, this is back in February, the EU has threatened to put UAE on a blacklist because of shortcomings in their AML prosecution. What the FATF report found was that in a 5-year period up to 2018, prior to their visit for the mutual evaluation, there were only 33 prosecutions in relation to money laundering. And FATF said that's way too little for a country, that's such a large economic center and where there's a perceived high risk of money laundering. And the EU agrees. And the EU, again, as I mentioned earlier, for economic substance, this could just be the EU helping to incentivize the UAE authorities to step up their enforcement actions. But this is a genuine risk. And what I've heard is that if the UAE authorities don't demonstrate that they're properly enforcing their laws on anti-money laundering, they are going to be put on a blacklist in June this year, and that's 6 weeks away, 2 months away. So that's why I say I think there's going to be there's going to be further intensification of anti-money laundering enforcement. So that's something we all need to be aware of if we're in a regulated sector. And with that, I'm going to end there. Thank you very much.
Thank you, Mr. Matthew, for addressing our members on ESR, UBO, and AML. Many thanks for highlighting few actions and penalties which were charged by the UAE authorities for non-compliance of these laws. Friends, I request a big round of applause for Mr. Matthew. Thank you, sir. Before I hand over to Jessica for Q&A, I have one question for Mr. Matthew.
Go ahead.
Yeah, don't you think that by introducing this DNFBP, responsibility to report on suspicious transactions have moved to auditors, accountants, rather than banks? So what is your thoughts on this?
I can see why you're saying that. So ultimately, I think what the authorities want is for that burden to be shared by everyone. The banks have to do their part, but I think they're now saying in the UAE, so do the auditors. I've seen some, and I'm not pointing the finger at the sort of established large audit firms, for example. I think they're all doing, a reasonably good job under a difficult circumstance. But I've been involved during investigations I've done in the UAE. I've seen some fairly egregious and obvious examples of money laundering in companies that were audited, had their accounts audited, but there were no suspicious transactions made. And so I think that to some extent, that sort of burden now is falling partly on the audit sector in particular, because it's really around the audit time where transactions get looked at a bit more closely. But I don't think that's to say that the banks will be taking their foot off the pedal, because they're also very much in the firing line, and their regulators are probably the most aggressive, particularly in the financial free zones. The DFSA and the ADGM are two extremely proactive regulators who don't hesitate to enforce if they see failures. But your point's a point very well made. Things are, the audit sector in particular is very much under the spotlight now.
Thank you, Mr. Matthew. I have one more question for Abhimanyu sir. Whether all UAE free zone LLC companies also had to review and amend MOA and articles effective 2nd of Jan 2022, because most of the companies are having standard MOA articles in the UAE. So what's your views on that?
Thank you. I think is the free zones that have their own company's law, they need to take a look into that. And those who do not have their own company law, they need to comply with it. My personal suggestion would be that in looking at any of this, it probably is prudent to take into the best corporate governance standards and slightly try to at least foresee what could be built into it based on compliance with what the laws are around you and international provisions. And I know when I am dealing with the client, I usually look at it other way around. That what you should not put into the law, what is prohibited by law, rather than saying what I must. In many ways, rather than simply just complying with the minimum law, it may be prudent to go into beyond what is the minimum standard and look into it whether it is mandated or not.
Okay. Thank you, Abhimanyu. Now I invite our EXOM member, CA Jayaprakash Agarwal, to moderate our Q&A session, which is one of the most important part of our virtual conference. Before that, I ask everyone, all our members, that please ask as many questions as you want from our speakers today, which is free of charge. FOC deal is valid only for the next 25 minutes, guys. So please use this opportunity to the fullest, because lawyers do not provide free of charge advice like we CAs generally do. Over to you, Jay, for Q&A. Thank you.
Thank you, Arizab. I love that part. This is the interesting part, Q&A. So we have heard them. Now it's our time to understand their questions. So, sir, first question, then this is for anyone can take. Mr. Abhimanyu, you can take this question. It says, which is the most common used screening software for customer due diligence? Most common used screening software for customer due diligence. Are there any approved screening medium expected from the regulators? So will they approve any screening modules? What do you think?
That question should really fall into Matt's side of it.
Yeah.
Perfect. Mr. Matthew, you go ahead.
Okay, so the one of the most common, I mentioned it in my talk, is WorldCheck. But in fact, right now there are, particularly on the fintech side, there are a large number of new providers who are using digital technology for carrying out customer due diligence. On FIDO is one of them. That's probably the best known name in the business. That really helps facilitate onboarding of clients, because it effectively allows you to do a lot of what used to be fairly manual automatically. It's really changed the industry, and the regulators never approve anything generally. They may say that they have no objection to using a particular piece of software or some sort of third-party app, but they won't approve anything. But I know on FIDO's had a very good traction, which means the regulators are clearly happy with it. But I mentioned on FIDO, I have no connection to them or to WorldCheck. I mentioned, but there are lots of other very good third-party applications for customer due diligence. And as I say, they're getting better and better every day as companies leverage the power of technology.
Perfect. So, I mean, they will not approve anything, but the software which is doing good, we have to go for that. With this, I go to the second question, and this is again for Matt. Matt, is there any whistleblower protection in the UAE? Matt, you will take it, you will pass it on to Abhi. Any whistleblower protection in UAE? So if someone comes forward, whistleblowers on any company, is there any protection available for them, or they will be exposed?
That's a good question. It's very much this area is under the spotlight at the moment. What I can say is that in the DIFC, they're looking to implement, the regulators looking to implement detailed whistleblower regulations. The DIFC already has two forms of whistleblower protection. The first one is in relation to anti-money laundering, whereby a company cannot prejudice an employee who makes a report on anti-money laundering to the regulator, to the authorities. And there's a provision in the, I think it's the company's regulations in the DIFC, or the company law, which contains whistleblower protections for certain disclosures made in relation to companies around, for example, things like their financial information. So certainly in the DIFC, which is, I'm much more familiar with, there is a reasonably good degree of whistleblower protection. But you know, in the UAE, I think what we're going to see more of in future, certainly in the next 6 to 12 months, is companies looking at anonymous whistleblowing hotlines. And if those hotlines are genuinely anonymous, then I think whistleblowers will have less and less concerns about whistleblowing in relation to bad activity. I mean, it's quite a complex subject, and I'm not sure we've got time for it now, but depending which sector you're in, it's not a case, sometimes it's not just a case of you deciding voluntarily to whistleblow. There are some provisions, for example, in the DIFC and the ADGM, where if you know of certain activities having been committed, you're required to, if you're, for example, a compliance officer or a money laundering reporting officer, you're required to disclose those to the regulator. In the UAE, it's really for the company to make suspicious transaction reports. But yes, I know there are concerns amongst employees about actually raising concerns about money laundering within the company, and that's, I think, held back the reporting mechanisms in the UAE. And I'm aware of a particular individual that I know who made a internal suspicious report, and he eventually was fired for that. So I think some employees are reluctant to do that. You may not be aware, but under the UAE Penal Code, if you know of a crime being committed, you're required by law to disclose that to the authorities.
Perfect. So it's not basically your obligation. I mean, it's not basically your will. It's your obligation to declare it. Otherwise, you will be falling under penal code. Thank you, Matt, for this. Now I will go to Abhimanyu. Abhimanyu, one question which we have is, in case of bankruptcy, what is the payment hierarchy which is recommended by law? In case of bankruptcy, the payment hierarchy.
Usually, you go to the statutory dues, question whether we have yet to see whether the employee debts are part of the statutory dues or not. Then you have the secured creditors, and then you have the unsecured creditors. In the secured creditors, you go in the list of filing in terms of the filing where it is there, and that's how your waterfall generally would need to work.
Okay, from secured to unsecured, and that is the flow which we have to go for. Matt, again, one question, because AML is something a really hot topic, so maximum questions will be coming on your way. The question is, I mean, people have already done Go AML and they have done the registration. What do you think is the next logical step which government will take, and where they should be ready, or we should be ready in terms of being chartered accountants or in terms of being our clients? So after Go AML, what next, Matt?
It's quite difficult to say what they'll do next, but what we've seen in other sectors is that they, after giving them time to implement their internal systems and controls, they've done spot checks. And what I have had first-hand experience of from both central bank and the regulators in the financial free zones is they tend to send out a questionnaire not that long after they implement the rules, and asking various questions to do with compliance. And what they do is they use the responses to that questionnaire to target certain companies that they will then follow up with a visit. That's a fairly common method of sort of catching out or finding out who is or isn't complying, because you can usually tell from the quality of the responses that are given to those questionnaires which companies know what they're doing and which ones don't. So that's what I've seen. That certainly happened in for example, the money exchange companies. They all received detailed questionnaires some time ago, and there was follow-up then from the central bank, and the DFSA does that regularly as well on the DIFC. So that's, I imagine. I mean, I can't see that. I can't foretell exactly what will happen, but it is likely that something similar to that will occur.
Perfect. So get ready for the copy.
Before that, I think if I could add to what Matt was saying.
Yes.
I think when you look at, I think one of the key points that Matt made, and I think is very relevant, is to understand the purpose. And I think the question was asked, which Matt had answered earlier, is what is the best software for AML. I think in my view, it is not necessarily a particular software or anything which you can say, I used ABC and hence my duty is fulfilled. I think we are all responsible professionals and we need to understand the legislation, and the purpose behind the legislation is that we should be assisting the government systems in preventing money laundering or anything that is illegal. If we are found to be assisting somebody escaping from that, liability could come to us, and that may be personal liability and criminal liability.
Perfect. So you are saying software is one thing, be clear with your conscience, what exactly you want to do. I love that part.
A higher duty of diligence based on put on professionals. So you need to know the law, and you need to be diligent in doing your duty in terms of whatever you need to comply with.
Perfect. I mean, this is the first time I've seen Abhimanyu smiling. I understand law. Matt, you can also smile. We discussed law, but we can smile and you can have that comfort. With this, Abhi, I go for another question for you. What is the difference between voluntary liquidation and applying for bankruptcy? Either I apply for voluntary liquidation or apply for bankruptcy. What is the difference between the two?
So in both cases, voluntary liquidation and bankruptcy is, typically a bankruptcy is a position where somebody else is taking you to the court. And voluntary liquidation is, voluntary liquidation, you may not necessarily be bankrupt, yet you want to go to liquidate your company because you have no further purpose business. I am assuming that voluntary liquidation you're asking now, the question is in the context of bankruptcy. So if you are in an insolvent situation, there are two ways you can approach the courts. Either it is the debtor who can go for the protection of the court, or it is the creditors of the company that can go to the court.
Okay, makes sense. I have one question on ESR, Matt. This is for you. You have seen COVID for last 2020. We are seeing COVID here, and people are reluctant to travel. The question is relating to travel. Is it necessary for the director to be physically present in UAE to attend the meetings to fulfill ESR conditions? How do you see it?
I've been asked this question quite a few times, actually. So a lot of foreign companies with foreign subsidiaries in the UAE will have directors who are based overseas for various reasons, partly to do with control of the company by the parent. But it's not been possible to travel over for ESR purposes to attend those meetings in person. Now, as far as I'm aware, the Ministry of Finance have not given any guidance on this, but what we've been telling our clients is that they're likely to take a fairly pragmatic view. If you can't travel, you can't travel. And if you've got to have a meeting of the directors, then you will simply have to do it remotely via Zoom. In some cases, and although I'm not sure if it's possible to do this outside the ADGM or the DIFC, but in some cases, clients of ours, and we've advised them on this, they've appointed what are called alternate directors who are effectively delegated the duty of the directors, that they become directors under the law and DIFC, that they then will sit and attend those meetings so that they can be physically present. So that's a fairly pragmatic solution. But we don't anticipate that the regulators will enforce on this due to the fact that compliance with the guidelines is impossible because of COVID.
Matt, if I could again add to that and ask the question is, I think compliance on ESR aside, if in this situation you happen to be sitting in a different country, I think you may want to be careful about what the tax laws of that country may state in this regard, because each different country has set out its own different guidance on how it is going to treat people who might otherwise be based outside, and how long could they be based in a different jurisdiction. So it may have an unintended consequences of the company being considered to have a permanent establishment somewhere else, and how the tax authorities in that country are going to treat that. I think is a completely separate issue.
Perfect. I mean, see a holistic picture and accordingly decide what you want to do. I love that part. I mean, the way you guys are answering the questions, I can see number of questions are going on increasing. Right now, I have 22 messages which are unread for me. I'll go with one specific case coming from one of the senior members, Kamlesh Manek. He says he has 2 licenses in different jurisdictions, maybe one in the free zone, somewhere other in the jurisdiction. and they want to register for AML, but they have a single compliance officer. Now, this may be a logistic issue. If they already use that email ID, which is assigned to that person for registration in Central Bank of UAE, they cannot use it for registration for another jurisdiction. What's the way out? Matt?
Yeah, I'm sorry, I was just on a meeting. Yeah, that's a very tricky question. I mean, technically, if your company's caught, you are required to register that company. But I'll have to. I haven't checked the details for some time now. I know I was asked this question a while back, but I believe, but this is subject to verification. I believe that the FIU, which is the statutory body that's established to receive suspicious transactions on GoAML, they will allow group registration, and therefore you would not need to register 2 companies in that situation. You would simply need to register one, but then make the suspicious transaction reports for the relevant group companies. But now I haven't checked the rules recently, and I'm not sure in this particular example whether they are group companies, whether they're related. If they're not, if they're simply separate companies, that may not work. But this is previously, I know that there was permission given by the FIU to have reporting at a group level, because some companies in the UAE will have a number of group companies under common ownership who fall within the regulated sector for AML. So that's how they've dealt. But as I say, I'd have to verify that's still valid and up to date, that advice.
Perfect. So Mr. Kamlesh will take some time, and he will maybe you can connect with them offline and then take it forward. Mr. Rabi, a question for you. Mike, this is relating to incorporation of the companies. The person is wanting to incorporate a financial advisory services related to crypto assets. So financial advisory is fine, but this is related to crypto assets. Can we incorporate the company in mainland with 100% for foreign ownership? That is what he's asking. Are there any special license, because it's crypto? So is there any special license which is required in this case to collect the funds and manage portfolios relating to crypto assets?
This is a very futuristic question, because I think we are still awaiting for the cabinet decision on what companies are going to come into. But if I were to take a punt on it, I think if such a company, I would guess, is unlikely to be in the cabinet resolution requiring UAE participation. That is my guess. And even if 100% is permitted, most likely it will require some sort of a central bank involvement there.
Perfect. So Santosh, you have to wait for the regulations to come in, and there will be some kind of involvement which will be required. Moving on, Mr. Matt, one question to you. This is for UBO. So we are jumping for topics for you from AML to ESR and now UBO. One question. It says, if the client does not file UBO, what is the penalty? And what is the form to file UBO for the mainland company? Is there an online form available, something like that?
Now, the UBO has to be filed with the relevant authority where you're based. So if you're based in one of the commercial free zones, then you have to register with the registrar. So you have to, the relevant forms will be with the local registrar. So DIFC, it would be registrar of companies, and ADGM, the ADGM authority. Be DD, I believe, for sort of typical onshore company. But I believe there are sanctions which apply in relation to non-filing of UBO, non-registration of UBOs. It will vary between the financial free zones and the onshore authorities. I don't have those, the level of the fines in front of me right now. I'm just looking at the regulation. I believe they were placed in a subsidiary piece of legislation. But yes, there are obviously consequences for not registering a UBO and also for failing to maintain the register of UBOs.
Perfect. So please go ahead and maintain the UBO. There are consequences. We don't want to get into it. With this, we go to the next question. It is coming from Ravi Chetnes. It says, are UAE foundations in scope or out of scope of ESR? Foundations, I'm not sure, maybe we are talking about charity foundation or something. There's a written question coming in. So are UAE foundations in scope or out of scope for ESR, economic substance?
I haven't been asked that question before. My initial thought is they're out of scope because they don't fall into one of the relevant activity areas. But it will depend ultimately whether the foundation itself does carry on any of those activities. But my initial thought is that they probably are not caught.
So, perfect. Mr. Ravi, be happy. You are out of scope. One more question to go for, and this is again for Matthew, and this is something the person has been very observant. He said, initially when the guidelines came out, it says real estate developers will also be covered under GoAML, real estate developers, right? But after a few days, he has observed that real estate developer word has been taken out and real estate broker and agent has been included. Why so? What was the reason?
Okay, so that's pretty straightforward. I mean, the definition of a DNFTB does not include developers. The definition includes real estate agents and real estate brokers. And the reason for that is they want to capture those persons who are directly interacting with customers, customer money, and interacting with the relevant transactions. So, and I think the deadline for registration was a couple of weeks ago for that sector. But developers aren't caught. Now, having said that, I've been advising one or two developers in the last few weeks, and it would capture you if you're a developer and you have a brokerage business. So a lot of the developers will have a real estate arm that sell property, and therefore they wouldn't automatically not have to apply. It depends on actually, and the government's taking a substance over form approach, and they're looking at actually what activity you're carrying on. So if you're a developer that says, well, I'm a developer, I don't need to register. If you're actually carrying out any brokerage activities, then you would have to.
Perfect. You got the reason. Now I will go to Mr. Abhimanyu. This question is more practical question. If the creditor has placed a claim without amount on a company under bankruptcy, company has gone for bankruptcy, creditor has put in the claim, but he has not specified the amount. Liquidators have asked for the details, but the creditors have not provided the details. Is there any limitation period which is applicable? Say 5 years has gone by and we say, no boss, now you cannot recover your money. So are there any limitation period? The claim is there, but amount has not been specified. Details has not been shared with the liquidators by the creditor. Is there any limitation period?
If the liquidator has asked, because typically just submitting a claim without the amount is not really a claim, it is just a possibility of a claim. So technically that filing in of the liquidator probably has the jurisdiction to completely reject that claim. And if the liquidator still is entertaining the claim, you may be able to challenge it. I think is once the liquidator sent out the publication in the newspaper, you have a certain number of days to respond to that. And if you do not respond to that in the specific format, you may not have a claim.
Perfect. So, I mean, you have to reply back, otherwise you don't have a claim. But is there a limitation period as well? After 3 years or 5 years, the claim you cannot do it because 5 years limitation period is over, something which we have something in India, not in UAE. How about that?
I think that there are two questions there. First is your general limitation period. And I'll have to come back to you on that. It may be, one of the 3, 6 or 10 year period. But that's a separate issue and outside of the context of bankruptcy. Once the liquidation proceedings are filed and there is a newspaper publication, you got to submit your claim within the period specified in the notice with full particulars. There is no dilly-dallying on terms of what you are able to provide that information and what you will provide in due course, because that uncertainty should not be entertained.
Perfect. So you have to provide the details. I have many questions here, but in the interest of time, we are on 5:45. I was given clear instruction by secretary that Jay, 5:45, you have to complete your Q&A. So what I will do is, I love that smile, Abhimanyu sir. I will go back to secretary and sir, over to you. My Q&A is over. Now back to you.
Thank you, JP, for moderating Q&A session so nicely. I think for crypto, there was a question I can highlight on that. Recently, for one of the clients we approached DMCC, he wants to do the trading in cryptos, and DMCC has confirmed in writing that he can do the crypto trading for himself under proprietary trading license. And as far as the exchange house is concerned for the cryptos, DMCC is coming up with the guidelines very soon. So please keep in touch with DMCC. And now I think we have reached to the last part of our today's virtual conference. I request our ExCom member, CA Priyanka Gupta, to propose the formal vote of thanks. Over to Priyanka.
Law, UAE bankruptcy law, and newly added emergency financial law. Thank you, Mr. Matthew Janan, for simplifying the law and providing your expert opinion on ESR and Anti-Money Laundering Act. It is always a hot, this is the most hot topic that we discuss as finance professionals. I would also like to thank Mr. Jay Agrawal for taking a lot of questions in the short time that you were given, and to our speakers, Mr. Abhimanyu and Mr. Matthew, for answering those questions with your expertise. And last but not the least, I'd like to thank all our beloved members to attend this session on a weekend afternoon. I hope that the knowledge that you've received from this session you will be able to implement, and it has been very fruitful for you all. Thank you so much again. Thank you. I would now like to request to provide a certificate of appreciation to our guests, Mr. Abhimanyu and Mr. Matthew, please. Thank you so much again, Mr. Abhimanyu, for giving the insights, and also thank you so much, Mr. Matthew. This is the certificate of appreciation for both of you. Thank you so much for all of you all for coming again today and attending the session. Thank you so much.
Many thanks, CA Priyanka Gupta, for formal vote of thanks. Now I think I wish all of you Ramadan Kareem, and stay safe, stay connected. Now we can have a snapshot video prepared by our technical team, AGP. Jay, you can unmute everyone so that we can have just a last interaction before we close the meeting.
They are from the audience side. Unmuting them will not.
Thank you very much.
Thank you, sir.
Thank you.
Thank you, Matt. Thank you, Abhi.
Thank you. Great session. Thank you,
Thank you.
guys. Take care. Bye.
Thank you.
Bye. Thank you all. Bye.
Bye-bye. Thanks, everyone.
Bye.
Thank you. Bye-bye.
Thank you, Mr. Matthew. Thank you, Mr.
Thank you. Thank you, ICI. And thank you, Mr.
Thanks a
Matthew.
lot,
Thank you, ICI.
you and the entire XCI team.
Thank you, everyone.
Thank you, XCOM.
Thank you all for attending.